When JPmorgan bought Frank, a company in 2017 started by a young entrepreneur at just the age of 24. What actually they agreed in the contract is that they will cover the legal fees for the Frank's executive if, say, for example, they're ever sued for anything that they did during running the company, so during that time. Now, why this is a problem is what I'm going to tell you today. Basically, Frank was having some customer base, but what the owners, the startup founders had done when JP Morgan was buying it, they had inflated its customers. So that means they showed artificial transactions and there was a lot of fraud that had happened. Yes, JP Morgan was successful in claiming damages, but at the same time, $115 million in legal fees, 19 lawyers for one executive, 16 lawyers for the other executive. And why JP Morgan had to cover all of this is because of the indemnification clause they signed in the JP Morgan's merger and acquisition agreement. Now, why I say that this is the entire issue is not just based on the big companies or for the big ones, it's also for people who are signing terms and conditions without actually understanding that who is this clause protecting actually. Now, when JP Morgan had signed, they would have never assumed that Frank's executive, the previous founders, would have done this, but they had to sue them because of the damages and all the fraud that had happened. And then JP Morgan also at the same time had to cover the entire fees. Now, what this shows is that as a person, as a layman, you and me should read the terms and conditions thoroughly, should understand what is the purpose of those clauses, should ask questions if need be, should do your due diligence. This is very important before your house burns, so you should know that what you are entering into.